and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hello, Richard.
Hello, Lizzie, and what have you been doing since I last spoke?
The usual joke when we're doing back-to-back podcast recordings.
Yeah, I'll think of a new one.
But that's all good. We've got another one to discuss, and this one is Lamba and Enfield Borough Council, and it's a High Court case. We don't have an exact date yet, as it was an extemporary judgment, but it's all about serving of notices in leases. And I think we'll start with a bit of background understanding of this area of law.
Actually, as far as I can see at the moment, it flies in the face of quite a lot of previous case law, and how much it depends on its facts is another matter. And so I can't take to tell you about the detail. I mean, it's been in practical law mentioned now, and they basically say they can't say much about it because we haven't seen the written judgment yet. Perhaps we'll revisit it if one day we do. It's extemporary, and the judge just gave the judgment after the case had been discussed and likes and heard. So there's a lot of things left open to it, but it's being talked about quite a bit. So I thought I'd bite the bullet and talk about it. I mean, it's always been accepted that in terms of serving notices, you take a sort of belt and braces approach. You just, if you've got any doubts whatsoever, you do hand and special delivery and first class post and leave it at the last known address and so on the basis that one of them's going to be right. But it's a conflict that's statutorily based, really. There's two commonplace pieces of statute to deal with service of notices in leases. One is Section 196 of the Law of Property Act, 1925. And it basically says you can either serve last known abode or business premises, or you can serve by first class post or registered special delivery. And it also goes on to say that if you use registered post, it's deemed to be served at the day it would be received in the ordinary post, which I haven't a clue what that is nowadays. But also it says if it's returned undelivered, it's deemed not to be served. Whereas the other commonplace provision is in Section 23 of the 1927 Landlord and Tenant Act, which basically says, well, you can serve again, you can serve registered post or hand or leave at last known address. And perhaps as I mentioned shortly, various cases have interpreted that as meaning the moment it's posted, basically it's deemed to be served. Section 23 of the 27 Act is the service provision under the Landlord and Tenant Act 1954, which is obviously a highly significant piece of leasehold legislation. It incorporates Section 23, Section 66, Section 4 of the Act does. And it's also, though wasn't discussed so much, it's also the notice provisions under the Landlord and Tenant Covenants Act of 1995, or the relevant provisions, including Section 17. So leases tend to include both. But if you want to make sure service has occurred, or so we all thought, then the best way of doing it is under Section 23 of the 27 Act, because once it's posted, it's deemed to be served, and if it's returned, it's still deemed to be served. And there's been various cases over the years which have discussed that.
And what have the previous cases said?
Well, I remember there's a case called Commercial Union and Mustafa. Obviously, again, I can't tell you which cases were discussed in the actual decision itself. Perhaps we'll revisit it, as I mentioned, one day. There was a 1999 case actually about the Section 17 of the Landlord and Tenant Covenants Act, which basically says that if there's been an assignment of a lease and you want to sue the original tenant, if it's a pre-1996 lease under privity of contract, they still are liable for breach of contract, for non-payment of rent and the likes, even if they've assigned the lease. Or if you want to sue under or a guarantor basically, then, or including an ARGA, then you have to notify the original party within 6 months of the fixed charge, the rent usually becoming due. And in Commercial Union in Mustafa, they posted the sort of, the Section 17 notice within 6 months, but it wasn't received until after 6 months. And the court decided it's still being served the moment it was posted. Probably the most important case, or definitely the most important case. There were a couple of Court of Appeal cases in 2002. One I remember well, Blunden and Frogmore Investments, that the lease allowed the landlord to serve notices. They incorporated Section 196 and Section 23 in the lease, but they allowed them to serve notices if the premises was unoccupied for more than 6 months. And it was unoccupied because it was blown up in a bomb explosion. You're not intrigued?
Always. What happened there?
Well, it's before your time, Lizzie. It was the 1996 Manchester bombing. Do you remember that? We wouldn't remember it because you weren't born.
Well, I don't personally remember it, but yes, I've heard
The
of it.
Arndale Centre in Manchester,
Yeah.
that was the IRA blew it up during the Euro 1996. And as a consequence, this premises, the landlord had helped the tenants, sort of move all their belongings and the likes, but 6 months later it was unoccupied. It was all cordoned off, you couldn't get there. But for whatever reason, the landlord basically did two things. He left a notice at last known address at the premises, even though the tenant wasn't there. They knew the tenant wasn't, and the tenant couldn't actually access the premises anyway. And they also served a notice with registered post, which obviously was returned. But it was still held that notice had been served by the Court of Appeal, both leaving at last known address, even though the tenants couldn't access, and also the moment the letter was delivered. There was another case called C.A. Weber and Network Rail Infrastructure from about the same time, actually, just beforehand, as we recollect, where they in that particular case, they served a Section 25 notice on the tenants opposing a new lease. And the notice has to be between 6 and 12 months in duration. And there were instructions by the tenant that not to deliver post and registered post and the likes on a Saturday. It would have turned up on the Saturday, but didn't actually turn up until the following week. And by that time, it was less than 6 months. So the tenant argues the notice is void. But again, it was held to be valid the moment you post the thing. It's deemed to be served. And there's another case called Beanby Estates and Egg Stores, which I won't bother you with, is about the 54 Landlord and Tenant Act again, but on a different version, the pre-2004 version. And they said the same thing. There's a whole line of cases. Galinsky and McHugh, I remember another one, which said if you use the Section 23, the moment the thing's posted, even if you never see it, you've served the notice, it's valid. And so on the face of it, it looks like, if they've incorporated both Section 196 and Section 23, that should be valid. But then came this case.
And what have they said in this case?
Well, in this particular case, they served registered post and it was returned. And they also served by first class post, but there was no evidence of when there was no date on the letter, basically. And so that wasn't accepted. But in the lease itself, it said that notices under or in connection with this lease shall be served in accordance with Section 196 of the Law of Property Act. And so the judge in this particular case said that trumps it all, if you like. Section 196 applies, and if it's returned, it's deemed not to be served. If you send by registered post, it's deemed not to be returned. And so the notice hadn't been served in that particular case, and it surprised a lot of people. We'll have to see the final judgment. There's a lot of question marks. Obviously, we haven't seen the final, the detailed version of this. And, that particular provision is worth checking if you're in the business of serving notices. But just because it says it shall be served under section 196, the argument must be, is that mandatory? Is that the only way of serving? And does that, notice under in connection with this lease mean statutory notices or just notices within the lease itself? But you might want to err in the side. I can't believe it's correct. I don't know if there's going to be an appeal. You might just serve by hand, last known address and likes, just to be sure in the interim. I'd still do I'd look for that sort of shall be served in accordance with section 196 if there's some sort of thing that looks like it might be mandatory. But we'll have to see the future. And that's another one.
Thank you very much, Richard.
My pleasure as always, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.